Okay, so in the last class we looked at the question of originality and the threshold of originality that's required for copyright protection. And we also talked a bit about the idea-expression dichotomy, which is really another consideration as part of the threshold of originality. What we're going to look at today now is who is the author of a work and for how long copyright protection lasts. For a book, it's fairly straightforward to tell who the author is the person that wrote it. But for other kinds of works that are given copyright protection, it's not as straightforward. So this is from the Copyright and Related Acts 2000 in Ireland. This is the Irish Act, okay? You will find similar provisions throughout the EU and in most other jurisdictions. So here we assign authorship to the producer if it's a sound recording. So if you record a sound, you're the author of that recording. And the producer may be the person that paid for it, I suppose, more than anything else. But so if you are out and about and you record something, you're the author of that recording. This gets quite complicated in the music business then, because as a band, okay, you might have the author of a song, which is fair enough. Then you have like your boy band singing it, but it's the person that makes the recording owns the copyright in the recording. And so you have all these contractual arrangements then to unravel that particular mess so that the band gets paid. Okay? So sometimes when you hear about artists complaining that they don't own the rights to the recordings of their songs because of whatever, that's what happened there. Okay? We give copyright protection to films. So the question then is, if a film is made, who's the author of the film? As opposed to, the scriptwriter or the author of the book that the film is based on. And so in this case, the author of the film is the producer and the director. The producer in a film is pretty much the person who paid for it. So I might decide to make a film, I'll pay the actors, I'll rent the studio, I'll pay the director, I'll pay the cost, I'm the producer. So then I'm the author in terms of copyright of that film. If it's there's some there I left out, they weren't interesting. The case of a typographical arrangement of a published edition, so say a book or a magazine, it's the publisher, not the graphic designer. This is a very interesting one here, very metaphysical. So if the work is computer generated, so if a computer creates a work that meets the criteria for copyright protection because it's sufficiently original and whatnot, the person by whom the arrangements necessary for the creation of the work are undertaken is the author. So if you're a programmer and you program the computer to generate a work, then the copyright rests with you, as you're the person who made the necessary arrangements. But that's quite broad. That could apply to the person who paid the programmer to do this, yeah?
So does that mean all the 3D models created in class in, let's say, whatever modules that are down there, they belong to CIT, or since they made the arrangements to buy the software with the license and buy the computers and get the class?
That's kind of a separate question. In answer to the basic question, is the work you create at CIT as an undergraduate your property or the property of CIT? That you'll probably find is governed by some sort of an agreement you made with CIT, perhaps without you fully being aware of it. There was a time when the work undergraduates did at CIT was considered the intellectual property of CIT. I think CIT no longer does that, but the work of graduate students is. So if you're, in general in Ireland and the UK, if you're being paid to do if you're at work, the stuff you produce at work, and even some of the stuff you produce outside of work might be considered the property of your employer. But I don't think CIT claims to be your employer as such, and it's not asserting any ownership rights over your creations, as far as I know. You might find in the regulation somewhere, in something you clicked a box you ticked somewhere, it might actually say that all of your intellectual property belongs to CIT, but I don't think it does. Separately though then, the person by whom the arrangements necessary for the creation of the work are undertaken, that's quite broad, isn't it, open to interpretation? I mean, if I was giving you a class and you were using lots of expensive CIT equipment to generate or between us, we eventually ended up with some computer-generated work, it would be debatable then as to who the person making the necessary arrangements for the creation was. Was it the president of CIT? Was it me? Was it you? We could argue that one out. But what's important is that just because the work is generated by a computer doesn't mean there isn't copyright in it. And it's also not giving the copyright to the computer. This avoids a scenario where work is generated by the computer and someone says, but you didn't make that, the computer made it. So how can you be claiming copyright in that? So this solves that problem. So if work is generated by a computer, the person who set that up is the owner of that. And we'll see in a minute that could be taken quite broadly as well. In the case of an original database, the individual or group of individuals who made the database are the authors. And in the case of a photograph, it's the photographer. So if a photograph is taken, the person who owns the copyright in the photograph is the photographer, which is quite interesting. And most people probably aren't aware of that until they get married and they pay someone to take pictures of their wedding where they don't actually leave with the files. And if you want to get more pictures printed, the photographer charges you more money. That's because the copyright rests with the photographer. So whenever a photograph is taken, the copyright is, the author is the photographer. So if I take a picture of you, I have the copyright in the photograph. And you might think, well, what about me? I'm in the picture. Well, tough luck. So this again, you can see, is this coming from a instrumental point of view or an author's rights point of view? It's all fairly instrumental stuff. It's like who made the investment. It's like the guy with the recording studio, the guy who paid for the film, the publisher, the person who owns the computer and set it all up. So this is all about giving authorship to people who have made the investment. I'm hoping so they can recoup their investment. So you think about, there was debates back in the Parliament in the UK when they were first giving protection to photographs. And there was some debate, there was some questions. And people were pointing out, well, I mean, it was very expensive to go off to Egypt to take photographs of things that cost a lot of money to go. And then when you came back, someone could just copy your pictures, you might find it hard to recoup your investment. But the originality of a photograph, in air quotes, is a tricky one. You know, if you're taking a picture of something, are you really meeting the originality requirement? And that was an issue. Now we've since decided you are, that's fine. But you can see how it poses a problem. If a photograph is just a capturing of reality, is that really a creative work? And the justification way back 100 years ago was, well, you know, it costs a lot of money to go off to hither and yon foreign lands and take pictures and bring them back. And we want people to do that, we want to incentivize that, but if someone can just copy them when they come back, well, who would do that? Now, who knows who this is?
It's the monkey that took his own photo.
Yeah, so this is Selfie Monkey. And he posed some interesting copyright questions because some photographer was there to take pictures. He dropped his camera, whatever. The monkey took a picture and the picture was published. You know, it would have been, oh, an interesting thing. This, you know, monkey took his picture. And then the photographer, or rather the man who owned the camera, was suing people for publishing the picture without his permission. He was like, you can't go publishing this in magazines and on the news and on the web. It's my picture. And this raised the very interesting question, who was the author of this photograph? And who do you think, what do you think should have been, do you think anybody should have been able to print this picture, or that the photographer should have got the money? I mean, the guy who owned the camera should have got the money, or, you know, the monkey should have got the money. Nobody should have got anything. What do you think?
I mean, if it's extending to intellectual property, then can you really extend that to animals?
Well, yeah, can animals be owners of intellectual property? I mean, that's a tough one. I mean, animals can own property. I mean, if you're a monkey starring in a TV show or something, I'm sure the owners of the monkey can set up a trust to look after the monkey, and the monkey wages go into, real money goes into a bank account or something that's controlled on behalf of the monkey. I don't know if you could say the monkey ever owns it, but
yeah, but it's not intellectual.
you know, it's not intellectual property, no.
I mean, a monkey can't really have intellectual property because it's not intellectual.
Yeah, I mean, that's a reasonable argument. Anyone want to agree or disagree? I suppose anyone want to disagree?
Just another point, but like another point we read that cameras are so advanced nowadays, it can be more user generated.
Yeah, I think that's an interesting point. You know, yeah, I mean,
go 20 settings at all. So,
like, if this happened 20 years ago, you'd be, oh my god, that monkey's a genius. He's able to work one of those really complicated cameras. I mean, there was a time you needed to set the focus and the aperture, which most of you don't even know what that means anymore. But there was a lot of work involved in taking a decent picture. To focus, look through, line up the proper focus point, focal point, and then you had to adjust the aperture in the camera by looking at the light meter, which gave you an indication of whether there was enough light to take a picture depending on the speed of the film. But nowadays, it really is, if the camera is decent enough, you know, anyone could take a picture. It's so easy, even a child could do it, or even a monkey could do it. So it was a tricky one. I mean, if the photographer had been there and he had set up his camera on a tripod, and there was some sort of sensor on the ground, and when the monkey walked in front of that sensor, it automatically took the picture. Would people have been, would it have been less controversial?
Probably, because that's the same as computer generated.
Yeah, I mean, I don't think anybody would have had a problem if he had set it up and sort of made the arrangements for that to happen. I think people said, okay, you're the photographer. You didn't actually push the shutter, but you set it all up so that when the monkey stood on that pressure pad or whatever, you know, everything was all set up and it took his picture. It is interesting to ask, you know, what the difference is.
I suppose could you say that you don't want to call him the photographer, he was the owner of the camera.
Yeah.
I mean, who's to say he had a better claim to the intellectual property rights in the photo than the monkey? He didn't really do that and left his camera there.
Well, he bought the camera, he invested all that money, he maybe hiked miles up a mountain, he probably paid, you know, bought the plane ticket. I mean, that's an argument.
In his part.
Yeah, I mean,
taking the photo.
Yeah, you know. So I mean, it's a tricky one. In the end, anyway, in the US, it was decided that only humans can be holders of copyright. So animals can't own intellectual property. Okay? The question, so the monkey didn't own it anyway, so the monkey wasn't the author of the picture. That was one of the points. Now, if the monkey was the owner of the picture, I mean, there was even a crowd of animal activists who went to court to get the copyright for the monkey, so the monkey would get the money. And they didn't get very far. But the monkey anyway wasn't the owner, wasn't the author. The question then was the camera owner the author? I mean, I think your argument about the camera being so complex, you could argue that the camera was a kind of computer and that the computer took the picture. In which case, the work was computer generated and then the person who made the arrangements for the creation of that work to be computer generated was clearly the owner of the camera. So I wonder, in Ireland, might that argument have worked? Because certainly cameras now are so sophisticated, you even have to ask, where is the labour, the skill and the judgment? No, I love taking pictures. I would argue there's actually still a lot, even with a really, really good camera, there's still an awful lot of the photographer as author in there. But you could see why people would ask, well, I mean, you know, cameras are so easy nowadays, point, click, yip-de-doo, you know, why are you calling yourself the author of this creative work? All you did was point the fucking camera back, you know. So you could see there's an interesting argument there to be had.
But the reason why they're so simple now is because they are computer controlled.
Yeah, they are computer controlled.
It is the computer generated.
Well, this is the thing. You do have, I think, the computer generated work get out of jail card here. That I think if this case was decided in Ireland, okay, the monkey still didn't take the picture, but the camera owner took the necessary arrangements for the computer to create the work.
What if your man rented the camera?
Mm-hmm.
Would it be completely changed then?
I don't think so, because he would still have made the arrangements. And if you go back to the instrumentalist view of copyright, the guy who bought the camera was clearly the investor, you know, in the creation of this work. He put some effort, you know, financial resources into that, and so on. He benefits should go to him. So I think, as far as I know anyway, this image is in the public domain. So anybody can use it, because the courts have decided that the guy who owned the camera wasn't the author. The monkey would have been the author, except monkeys aren't allowed to be authors. So, tough. So anybody can use this now. There's another interesting development recently. This is a headline from The Guardian last year. And this is the issue of who the author is very relevant, because it connects to what we're going to look at next, which is the term of the copyright. And so if there's some wiggle room as to who the author is, then there may be some wiggle room as to whether the work is actually still covered by copyright or not. So for a book in Europe, the copyright expires 70 years after the death of the author. And Anne Frank, God love her, we know when she died. She died quite young, and that was more than 70 years ago. We also actually know when Hitler died, and his work, the copyright on his work expired also. And the issue came up then that this book that she had written, which was generating quite a bit of money, it was certainly not a trivial amount of money. I'm sure anything I write 70 years after I'm dead won't be worth much. But Anne Frank's book was still generating quite a bit of money, and because the 70th anniversary of her death had passed, the book was in the public domain, which meant it was out of copyright. However, her father, who has since died, but he died much, much later, it has been claimed now that he is the co-author of her diary, so that he edited it to so great an extent that he should be considered an author of her diary also. And because he died only in the 80s, I think he was still alive till quite recently, then the copyright wouldn't expire until 70 years after his death, which is still quite a few years away. And so that's still being argued. Which brings us to the duration of the copyright. So how long does the copyright last for? And as I said, for a book, it's 70 years after the death of the author. If it's a literary, dramatic, musical, or artistic work, or an original database, then 70 years after the death of the author is when the copyright expires. The Act in Ireland makes some provision for anonymous works or works written under pseudonyms. So what happens if you write a work anonymously? How do we figure out then when to have the copyright expire if we don't know if you're dead or when you died, because we don't know who you were, stuff like that. So it has some details to work around that. Suppose you write a book under a pseudonym, and then after you die, your kids say, actually, you know, the secret author who you're wondering who was all along was my dad. He just died, so I want money, I'm going to get money for the next 70 years from now on. So there's provision made for that. What do you think of 70 years, though? What do you think of that time period? So it's pretty much now. So across Europe, the exact wording will be different because it's regulated by national laws in each member state of the EU. But there was legislation passed at European level. There was a directive to harmonise the terms, so it's the same everywhere now. What do you think of 70 years, though? Fair?
Yeah, it makes sense in modern context.
How come?
Just like media, just trends move very quickly. So I suppose what popular now will make its money for about 10 years. Then it's like it's
So you're saying that you can make your money very quickly. So why stop someone doing stuff? Why stop someone from using your work like 70 years until 69 years after you're dead? Why stop someone if you made your money or you had your chance and you either took it or didn't? But like,
It's a bit much. I mean, with 70 years, your children can then inherit your works, which doesn't really fit the whole trying to encourage people to make original works, because then the children can just ride the waves of the parents.
I mean, that's an important point. If the purpose of copyright is to incentivize the creation of new works, it is very hard to incentivize dead people. Like, oops, you died. Actually, you could come back from the dead. You could make some more money. Never happens. So there is that sort of very basic argument that you can't incentivize dead people. However, if you were very young, if you died very young, it would seem a bit harsh that, your kids and your wife might get nothing because you're dead, if there was no copyright after you died. Or if you wrote a fantastic piece of work, the greatest novel ever written was written a year before you died, it might also seem a bit harsh that you might get nothing after that. So, there is an argument too for having some term after you die. Or maybe you should just have a term, maybe like you publish something and then you get 10 years or 20 years to make your money from it. Whether you die or not, perhaps. That could work. There are different approaches. Anyone have any ideas or thoughts? If we were all moving to an island, set up a society, we decided we were going to have intellectual property, we decided we were going to have copyright, would we plump for 70 years after you die?
Because you have to pick something, don't you?
You have to pick some point. Yeah, well, you have to pick something and go with it, yeah. So like in the Statute of Anne, it was 14 years after you published it, and you could renew it for another 14 years, I guess, if you felt there was still life in it.
Yeah, didn't Warner Brothers lose a case a couple of years ago where they were trying to get money for Happy Birthday, the song Happy Birthday?
Yeah.
They were trying to own the copyright to that.
Yeah, Happy Birthday is a bizarre one because even the people who they were claiming wrote it were dead quite some time.
Written in the 19th century.
Yeah, that was a strange one. That went on for quite some time. Anyway, so some people think 70 years is a bit too long. It was 50 years in a lot of places, and it's kind of been harmonized now more and more. It poses some problems for works where we don't know who created them. So if you're in a library and you find a book and it doesn't appear to have an author, the number of things you can do with that are quite limited, because if you're not sure that the person is dead 70 years, you could get screwed for using the work. But if you don't even know who wrote it, how can you be sure they're dead 70 years? Now, if it was published in 1800, well, then they're obviously dead 70 years. But if you don't know, that causes a problem. So that's something we might look at in another class, this problem of orphan works, where we're not quite sure who the author is, and so then those works are locked up for quite some time. But it does mean that nobody can do anything with Harry Potter until 70 years after J.K. Rowling is dead. If I was to write something today, we were going to be generous with my life expectancy, you might be talking what? It could be 2120 or something before the copyright would expire on stuff that I've done. So it's not even now just about supporting your family after you die, or having your kids having some income. At this stage, at 70 years, it's really down to your grandkids. And so society does have an interest in freeing up works. But of course, publishers and authors want that term to be as long as possible. And people have argued that 70 is probably too long. What do you think? Do you think 70 is fine? Have you been brainwashed by the man? Or... I mean, I'm not sure it factors much in the incentive. If I write a novel and it's successful and I make money, the money would be coming in 70 years after I'm dead. Because it probably won't. I know there's kind of a long tail now where, you can download stuff and things will have much longer shelf life than they used to have. But it still seems like not really factoring much into the maths, the equation, the incentive. Anyway, yeah.
Does germination is software not copied? Is it not covered under germination?
We decided software was literary work. So if someone writes software, the copyright on that will expire 70 years after they're dead, unless you don't know who they are. In which case, it would be an anonymous literary work. So if it's anonymous and there's no... If it's anonymous, Part 2.
70 years after the date of the work is lawfully made available to the public.
Right, so 70 years after it was published.
But, software companies work, it's like Adobe releases Photoshop 1.0.
Yeah.
And then 4 years later release another
Yeah.
version. Does the 70 years is scaled stacking, or is this 1.0 is set?
No, because the version 4 is new work. Well, of course, you could argue how new is version 4 of Photoshop compared to version 3, and should version 4 get a whole new copyright?
What about updates as well?
Yeah, that's a tough one. I mean, if you publish a work, if you publish a piece of software, and then you update it 2 years later, does the clock start ticking again? That's a tough one. I don't know.
Major versions or shit.
It hasn't really come up because there isn't a lot of 70-year-old software lying around that's being disputed.
And plus, I suppose authorship changes hands a lot. People leave.
Well, no, the authorship could be difficult to determine as well. So anyway, those are for literary works. If it's a film, when does the copyright expire? Well, there's 4 people involved. There's the director, the author of the screenplay, the author of the dialogue, and the author of music specifically composed for the film. And you have to wait until 70 years after the last one of those is dead before the film enters into the public domain. There aren't a lot of films in the public domain because we haven't had film for very long. I mean, if you think of the Lumiere brothers, when were they about? Their stuff would be in the public domain. But so yeah, there is a lot of dispute about the first Mickey Mouse films and when the copyright expired on those. Anyway, so 70 years after the death of all of these, that's when a film expires, copyright in a film expires. For sound recording, it's 50 years after the sound recording is made, or 50 years after the recording is made available, which is probably why Bob Dylan recently released some stuff that hadn't been published before. Didn't even make a lot of copies of it, but now it was being released to the public. It was good for another 50 years. Even though it may have been recorded donkey's years ago. So that's an interesting one. Sound recordings, 50 years. Broadcast, 50 years, not so much interested in that. Computer generated is 70 years after the date on which the work is first lawfully made available to the public. Which is interesting. So it's not 70 years after the death of the person who made the arrangements for the computer generated work to be made. Who knows, you might in 60 years or 70 years or 80 years have some dispute about whether some computer generated movie is a computer generated work or a film. That could happen, but I don't think so. No. Okay. So that's authorship and term. And they're connected because whether something is still covered by copyright or not will depend on whether the term has expired, and the term is based on who the author is. And for different kinds of authors and different kinds of works, you have different kinds of terms. So in the next class, or classes, we'll look at exemptions for copyright. So as we've seen, you can't do anything with something if it's protected by copyright. You can't copy it, you can't display it, all sorts of things you can't do, but there are certain exemptions. And we'll look at those in the next class.